Thank you, Mr. Chairman. Mr. Bennett, welcome, and welcome to each of the other members of the panel as well. Wendy, congratulations. Mr. Bennett, you and I have known each other a long time. I respect your service and honorable service as Attorney General in Hawaii. I will confess that some of the positions that you took as Attorney General give me pause for consideration for a lifetime appointment as an appellate judge. So I want to take an opportunity for us to discuss them. In Heller versus District of Columbia, as Attorney General, you joined with Massachusetts and New York and New Jersey in defending D.C.'s total ban on possessing an operable firearm in the District of Columbia. And indeed, you joined the position that the Second Amendment protects no individual right to keep and bear arms whatsoever. Why did you join that brief, and why did you take that position?
With respect, Senator, the merits brief that we joined asked the Supreme Court in Heller not to decide whether or not the Second Amendment was applicable to the states, because they did not have to decide that issue in Heller as Heller applied to the federal government. And the brief also specifically said that the amicus states were not defending the particular pistol ban at issue as a matter of public policy or otherwise. And the brief also said that none of the amici states had such a ban. Hawaii did not. The reason Hawaii joined that brief in Heller was to take the position that the court need not reach the question of whether the Second Amendment was incorporated and applicable to the states.
Well, and obviously that second question about incorporation vis-a-vis the states wasn't decided until McDonald as a subsequent case. Are you saying that the amicus in Heller that Hawaii joined took no position on the merits position of whether the Second Amendment protects an individual right to keep and bear arms?
No, Senator. I think if you read the brief in full, it certainly dealt with that issue, but the primary point of the brief by Massachusetts was the incorporation point, when it became absolutely clear, of course, after the Heller decision, that even though the court did not explicitly reach that point, when it became absolutely clear that the court was going to, in the appropriate case, incorporate the state. I believe that I made a public statement to that effect after the Heller case, and the state of Hawaii did not join any amicus brief in the McDonald case because, again, it was clear from Justice Scalia's opinion writing for the court that the Second Amendment was such a fundamental right in America that it was going to be incorporated and applicable to the states. The state of Hawaii has a Second Amendment analog in its constitution, as do most states.
So the brief you joined took the position that it was entirely consistent with the Second Amendment.
I believe
for a jurisdiction to prohibit all operable firearms.
No, Senator, I don't believe so, although it was Massachusetts's brief. I believe the primary point of the brief was that the court need not reach, based on precedent, the incorporation question. I believe the first heading in the brief was, if I'm recalling it correctly, the Second Amendment is not applicable to the states.
Well, and in Heller, that was not a disputed point.
It was not a disputed point, sir.
I'm concerned also about your record on civil liberties questions. In the Kelo decision, you joined a brief urging that governments have wide power and authority to condemn private property for private uses rather than public uses. Why did you join that brief and take that position?
Senator, I believe that the primary point of that amicus brief, and if I recall correctly, there were many states that joined it, was to urge the court not to change the standard of review in discussing these cases. And one of the primary cases that was at issue in Kelo was a case, Midkiff v. Hawaii Housing Authority, which had directly affected the state of Hawaii, laws then and still at issue in the state of Hawaii.
Last question, just because our time is running out. On the First Amendment, in both Citizens United and Stevens versus United States, you took positions that were rejected by the court, and you took positions taking a very narrow view of what the First Amendment protects. What is your view of what is protected by the First Amendment, and why did you take positions in litigation arguing for a very, very narrow interpretation of the First Amendment?
Senator, the amicus brief in Citizens United, which I believe was subscribed to by more than half the states, was simply that Austin should not be overruled. That was the premise of the brief in Citizens United because of the reliance interests of the state. But in answer to your second question, if I am fortunate enough to be confirmed on the Ninth Circuit Court of Appeals, the decision of the Supreme Court in Citizens United and all other cases dealing with the First Amendment, an obviously important right in our Constitution, would be binding precedent that I absolutely commit to faithfully follow.
Thank you.